Good afternoon. Good afternoon, everyone. Welcome to the Center for European Policy Studies. It is really an honor for us to have this event, this seminar, with the Commissioner Nils Muižnieks, Council of Europe Commissioner for Human Rights. It is really an honor for us to have him here, since he was appointed in April past year as Commissioner. We were really seeking having the opportunity for him to come, present his work, his views about some central debates in relation to questions of mobility and minority rights. And we managed, so I would like to express our gratitude on behalf of CEPS and the Justice and Home Affairs section, represented by Professor Elspeth and myself here. It is a very special year for CEPS. As a think tank in Brussels, it's 30 years already of work, and 13 years of work by the Justice and Home Affairs section. And during this time, we've been very active in questions related to human rights, questions, providing independent research, independent analysis on issues related to freedom, security, and justice, and questions related to mobility and borders have been indeed central. We've cooperated also. We've had several occasions, the unique opportunity to cooperate with the Council of Europe, Brussels office, in the co-organization of several events, and also with the previous Commissioner in various several events as well. I think that for us, having the opportunity to have you and let us know your views about this very sensitive question, yet relevant and necessary to address without hesitations. The question of criminalization of irregular migrants and minorities in Europe. What challenges for human rights? We consider it to be central. It is indeed a difficult period for the European Union in terms of economic and financial crises, which have very profound social implications, not least human rights implications. And it is for those people who are more vulnerable, which perhaps more attention, care, and policy responses are necessary. And here the European Union could play a role, and is playing a role. And we hope that this, also the discussion of today, give us more food for thought about the future action of the European Union in this area of undocumented migration and minorities in Europe. Having said that, I will leave the floor to you very briefly, presenting your background. As I said before, you were officially elected in January 2012, and since April you've been very active in getting on a coverage, following up, getting awareness, promoting awareness, the respect of human rights in indeed 47 member states across Europe. Your background is really impressive. You held very prominent posts before becoming a commissioner, such as director of the Advanced Social and Political Research Institute at the Faculty of Social Science in Riga, also chairman of European Commission Against Racism and Intolerance. So all in all, thank you again for being here. We are looking forward very much to hear your views about this subject. Please.
Well, thank you very much for this warm welcome. I'm very pleased that I could finally make it. We've been trying to hook up now for almost 11 months, and I hope that we can meet frequently in the course of my mandate over the next 5 years and 1 month, and afterwards as well. I followed the work of CEPS for a long time in various fields, not only in this field, but in other fields, and I have a great respect for what you're doing. And also, of course, we've had excellent cooperation with Elspeth on an issue paper on this issue precisely. I see this opportunity not only to share my views with you, but hopefully get ideas, insights for my country work and my thematic work. I think that I keep on telling people, exploit me. Don't abuse me, but exploit me. The mandate of my office is relatively unique. I have access to ministers and parliamentarians and ombudsmen and human rights defenders all over Europe. I have discovered that the media pay much attention to what I say. I have certain abilities as well, certain opportunities to intervene before the European Court of Human Rights as a third party, which I have not yet used, but I hope to use. I'm looking for good cases. So I urge activists, advocates, and experts to make use of the opportunities in my office and bring to our attention issues both regarding countries, regarding cases, and regarding trends in this issue area, because it's going to be on our agenda, I think, on a very high place on our agenda for a number of years. I've been asked to speak about the criminalization of migration, and I think this topic is more topical than ever. And I've seen this in very stark form on a number of country visits. I recently returned from Greece, where this is a very widespread phenomenon, not only with many people in detention and special detention facilities, but held in police stations, and not only irregular migrants, but asylum seekers from Syria who clearly cannot be removed and deported. I saw it in Italy on a country visit there, where I saw some of the most desperate people I've ever encountered in a CHIA, a pre-deportation center. People very often who had already spent time in prison for various offenses, and then the Italian authorities discovered upon their release that they had no legal status in the country, and then imprisoned them again in worse conditions prior to their deportation, but many of them cannot be deported. And I recently saw this in the former Yugoslav Republic of Macedonia, where a different form of criminalization has taken place with regard to many Roma who have sought asylum in various European countries, but whose desire to leave or travel has become criminalized. I met whole roomfuls of Roma whose passports have been confiscated by the authorities and encountered various forms of profiling at the borders. So this issue is one that takes many forms and that I've encountered in a number of different places. I think what's interesting is it's not really a new issue. There are certain new aspects to it, but I guess it's been with us for a while, and you know this probably better than I do, that criminal sanctions or administrative sanctions that look like criminal sanctions, such as detention, have been applied for many years in response to irregular entry and presence of migrants. And I think the language of criminalization is also not new. If you read a lot of the discourse analysis of discourse surrounding migration, it's all about criminalization. I think what is new is that criminalization is now enshrined in some EU documents, such as the 2008 Return Directive and the 2009 Directive on Sanctions against Employers for those illegally staying. This is pretty new. I think that this terminology has found its way into EU documents and has gained some legitimacy. And I think this choice of language is absolutely crucial for migrants. I think the terms illegal instead of irregular are stigmatizing. Illegal makes this movement, all movement, suspicious, links it immediately to criminal law. And I think the situation is compounded when you begin to talk about when the metaphors of natural disasters and war are attached to this discourse of illegality, of floods, inundations, invasions. In Greece, the term used was bomb, the migration bomb. And I think too often we see that these issues pertaining to migration are used to gain votes, particularly by racist political parties. As I mentioned, in Greece, of course, this is what Golden Dawn has capitalized on, not only the migration crisis that has engulfed Greece, but the economic crisis, which are... despite this rhetoric and these policy trends we've seen, I think it's really striking if you look at the official figures that In 2010, third country nationals in the EU were only 4% of the population. This is not an invasion, an inundation, a flood, a wave. It is a very small percentage of the total population, and the figures are declining. You don't really, if you were to read newspapers and listen to the political rhetoric around Europe, you would have you would get the complete opposite impression. And I think that the preliminary 2012 data indicate a downward trend, and I think it's primarily probably due to the economic crisis in Europe. It's clear that not all European countries face the same pressures, and that the South has much higher irregular migration flows, countries such as Greece and Italy and Malta, and there's a dire need for solidarity and shared responsibility. I think my predecessor didn't come straight out and say it, but I found out that one of his hidden goals was the destruction of Dublin returns, and I think it's a good goal. I think that these Dublin returns are unjust. They put untenable pressures on the countries in the South, and I think there's absolutely no alternative to rethinking Dublin returns, and I think there's an urgent need to rethink them. Imagine if Greece, after many years of having a broken asylum system, is finally fixing it. Are we going to punish Greece when it fixes its system by recommencing Dublin returns to Greece? Will this be the reward they get for fixing their system? Dublin returns have been halted by many countries through legal challenges, both in the European Court of Human Rights and in national courts. But if the situation in Greece improves, what then will other European countries do? Will we punish Greece for its success? I think that would be highly unjust, and given the political situation within Greece, I think it would be a disaster. States, of course, do have a legitimate interest in border control. They can refuse entry and stay of non-nationals, but I think there are the international and European human rights instruments, especially those governing the right to seek asylum through fair procedures, that need to be recalled over and over again, and of course the principle of non-refoulement. However, what we've seen is that some countries have such quotas on how many migrants should be found and deported through fast-track procedures, which of course throws doubt on the fairness of these procedures and the right of non-refoulement. Also, I mentioned about former Yugoslav Republic of Macedonia, but it's not only there, it's in Serbia and Macedonia, in Serbia and Bosnia and Herzegovina as well, attempts to criminalize, the criminalization of attempts to enter other European states and to seek asylum. I was first alerted to this about a year ago by human rights defenders in Serbia, who said they were beginning to get cases of people who had been taken off planes, had their tickets confiscated, with no compensation, with no recourse, and with no judicial review whatsoever. You have not only that, but you have racial profiling, confiscation of passports, and a whole series of measures, which is basically the outcome of the EU and EU member states outsourcing their bad migration policies and making the Balkan countries do the dirty work. This puts putting a criminal stamp on attempts to leave the country or enter another country undermines the right to asylum. And I think especially those who are smuggled into a country should not be seen as having committed a crime. There are also international standards that protect persons who are victims of trafficking from criminal liability. We have the 1990 Convention on the Protection of the Rights of Migrant Workers and Members of Their Families. Holds that if migrants are detained for violating provisions relating to migration, they should be held separately from convicted persons or those on remand. In other words, they are not criminals and should not be treated as such. Criminalization is disproportionate. It exceeds the legitimate interests that states have in controlling borders, and it equates migrants with smugglers or employers who exploit them. In other words, immigration offenses should be administrative in nature and not criminal. And I think the bad aspect, which we're also seeing, is that there are a number of side effects of criminalization I think, which are very harmful to human rights as well. One is overburdening court systems. Many member states that I've encountered have problems with length of proceedings in violation of Article 6 of the European Convention of Human Rights. And this leads to many, many applications before the European Court of Human Rights, which then again, which undermines the viability of the whole system. And the second kind of side effect of criminalization is overcrowding in prisons and detention centers. Just yesterday, met with an Italian journalist who was talking about conditions in prison. I said, listen, how wealthy a country are you? How many people can you afford to put in detention? You must be very wealthy if you can put so many people behind bars. It doesn't work. It is inhumane, it's degrading, it doesn't lead to rehabilitation. But categorizing irregular migrants as criminals entails both pre-trial and post-conviction detention. So in other words, there's no, if you go this route, you will have other problems in addition to a migration problem. You'll have overcrowded prisons and an overburdened court system. One issue which I've discovered that journalists in Brussels are particularly happy to hear about is our critique of the EU directives allowing for detention up to 18 months. I think this is an awful policy. This is the lowest common denominator being made a standard within Europe. You can generally determine if you can remove a person and deport them in a couple of weeks. So why detain them for up to 18 months, especially if you cannot deport them? I think it's ineffective, it's costly, and it's traumatic. And a human rights approach would be to implement alternatives first if release or temporary admission is not granted. This means systems such as registration and reporting, controlled release to individuals, family members, NGOs, and so on. But this migration, in the migration debate that we are seeing, we rarely, especially among politicians, it rarely includes human rights aspects and human rights standards. We also often forget that irregular migrants are coming and working not only to flee poverty and persecution, they're coming because we want them. There is a demand for migration in Europe, in many sectors, in the IT sector, in agriculture, tourism, and healthcare. So we are pulling them as well as other conditions are pushing them. And I think the lack of clear immigration mechanisms and procedures for legal migration is one of the problems leading to this. Then there's very little cooperation between sending, transit, and receiving states. There used to be a good forum in the Council of Europe for this, a working group on migration, which has been unfortunately disbanded. It was one of the few fora in which different sending, receiving, and transit countries could meet. I welcome the European Commission's willingness to pursue the migration dialogue with Turkey. I think it's absolutely essential. We're going to get a grip on migration in Greece, which a couple of years ago was 90% of all migrants entering the EU. Much more needs to be done with Turkey. But I think that the key thing is to establish transparent and efficient avenues for legal migration. Of course, accession to the 1990 Convention on Migrant Workers would be very good, but it's been ratified by very few European states, despite the fact that they had a key role in its drafting. The criminalization of migration sometimes targets national minorities as well as migrants, and this is a case primarily Roma, not only in the sending countries but in the receiving countries as well. Of course, the harsh responses to Roma immigration that we've seen in France and Italy, these are the most well-known cases, but you have it elsewhere as well. I understand in Belgium it's not unknown either to have discussions about this. I think clearly we need to focus a lot on the countries of origin, especially the candidate countries in the Western Balkans. I think that clearly the root causes, what are the root causes of Roma migration? It's poverty, it's discrimination, it's violence, it's social exclusion, it's anti-Gypsyism. I think the fact that Roma from the Western Balkans are overrepresented in asylum applicants basically reflects their abject misery on the ground and the failure of Roma integration strategies there, but not only there, in many other countries of Central and Eastern Europe. And this needs to be part of the institutional reforms that the EU is pushing for in the Western Balkans and further east. In my own country work, I've identified a few core issues pertaining to the Roma that we are trying to address. One has to do with segregation in education. We addressed this in the Czech Republic in a report that was published yesterday. On the 5th, I organized my visit to the Czech Republic on the 5th anniversary of the DH against the Czech Republic judgment, and very little has been done to address segregation in education there. In a forthcoming report on the former Yugoslav Republic of Macedonia, this is a core issue as well that we have tried to address. But it's not only in these countries, it's in many countries where this issue is very topical. And I try to convince the authorities. This is in the Czech Republic, for example, segregated education costs 2.5 times more per pupil than regular education. In other words, you must be a very rich country and have very tolerant taxpayers if you want to pay so much for substandard education that then creates a fertile ground for racism, but also limits the life chances of these people and is bad for the society as a whole. Another issue that I'm trying to raise, I just came from a discussion on it actually, is on statelessness among Roma, which is very widespread, not only in the Western Balkans, but among people who have left the Western Balkans. In Italy, for example, a very large population of stateless Roma. Because without education, Roma will not have a good chance in life, and without citizenship and documents, they cannot access many social rights as well. Finally, one thing that I've been pushing member states of the Council of Europe to do is, in all of their efforts to combat, to basically promote Roma integration, to include the element of combating anti-Gypsyism. This is one thing that I'm very glad that the EU required member states to develop and implement Roma integration strategies, but they forgot the critical element of dealing with the prejudices of the majority. Without doing that, no Roma integration strategy will work. And I think that here the EU could do much more in requiring member states to move forward on this, but also of candidate countries and neighbors. Let me conclude by saying that criminalization is first a political, and only then, I think, a legal construct. I think the stigma of attaching this label of criminal on a person who migrates irregularly is contrary to international human rights. It's not only that, but it's counterproductive. It makes rational human rights-based debates on migration much more difficult, and it impedes immigrant integration. The time in detention, up to 18 months under the EU directive, complicates the efforts of immigrants to integrate into society. It tars them as suspicious criminal characters. Who would want to integrate a criminal? So the point that I would make is that there's no alternative to immigrant integration, and anybody who claims otherwise, I think, is a charlatan or short-sighted. So I think that the sooner we realize this, the better. So I think we have to talk not only about our migration policy, but we have to think beyond migration and think about immigrant integration as well. And this is a debate I think that Greece and Italy are only just beginning to have now. Because I think giving people status is very good, but if you give them nothing after they have status, that's a recipe for disaster as well. So I think we have to think several steps down the line, not only of the entry and regularization, but what happens afterwards. Otherwise, we will all pay the price in social tensions and in violated human rights. Thank you for your attention.
Thank you very much. Indeed, I think one of the messages that's coming out of your presentation of utmost relevance in certain debates in Brussels is that indeed we need to come to terms that human rights and rule of law inside the European Union cannot be taken for granted, that this is ongoing work, and that perhaps certain of the premises upon which the European Union has been built need to be rethought and rediscussed. We are based, the European Union's area of freedom, security and justice is based on the premise that there is mutual trust and confidence between member states, respect of fundamental rights and freedoms and rule of law, and we are seeing, you were referring to judgments from Strasbourg on Dublin, telling us otherwise, that there needs to be a recalibration between trust and mistrust in the European Union, and the European Union needs to devise perhaps new mechanisms, new instruments which allow for such a recalibration of confidence in issues such as asylum, but also criminal justice cooperation. The European arrest warrant is another example. I think that's also another question that you mentioned. Who are we talking about when referring to the criminalization of irregular migrants and minorities? Here the question is, are they foreigners? Are they citizens? Are they minorities? The answer to that question is central, and this is an issue we've addressed in a new book, which has been published recently in Ashgate. We gave you a copy, Foreigners, Refugees or Minorities. Thank you very much. You find information in the table, and we hope you will enjoy it. This was precisely the question we raised, the question of Roma. Most of the Roma subject to evictions, for example, in France, these are EU citizens. And the presumption there is also, on the basis of the Aznar Protocol, that no EU citizen can seek asylum in another member state. And this is posing a whole series of issues and problems, not only inside the European Union, but also in international relations with Canada. And this is one of the topics we are addressing in this book, the EU-Canada visa dispute, on the basis of this affair, which is still open. It remains still open. I think we will have time for questions after having our discussions. Before introducing all of them, just to say that this event falls within the context of a project, of a research project, providing evidence on these questions, funded by DG Research of the European Commission under the 7th Framework Programme. The project is called FIDUCIA, European Crimes and Trust-Based Policy. Questions of trust and mistrust are indeed central in the project, and CEPS is providing the research on questions of migration and minorities. We just started. We kicked off with your speech, and we will now, for the next year and a half, get deep into analyzing cross-comparatively what member states are doing or not doing in respect of all these practices, debates, laws in relation to criminalization. Having said that, I move immediately to our first discussants. We are also very pleased. We have an excellent panel of discussants, starting with Michele LeVoy, a platform for international cooperation and undocumented migration, PICUM, with whom we've cooperated in several occasions over the years. Very fruitful collaboration, not least in the context of FIDUCIA, where you will be part of the advisory board. Michele has been director since 2006 of PICUM, and I have to say that she's played a decisive role in bringing the debate about undocumented migrants and rights, and that undocumented migrants have rights, into terms in EU debates. And it's really a pleasure to have you here. Michele, you have the floor.
Thanks very much, Sergio, for that warm welcome. And thanks as well for the invitation. I think it's really an honor as well to be on the panel with the Commissioner, with the other speakers, and to exchange with all of you. What I'd like to talk about briefly, and also response to the Commissioner, is undocumented migrants here in Europe. We've seen in recent years, and the Commissioner also outlined it, an anti-migrant discourse. We've seen this taken up by the far-right parties that have tried to capitalize on fears of the electorate, the financial crisis, genuine fears and concerns about their own future, and try to use scapegoating of migrants as one of the ways to try to shift the attention, blaming newcomers for existing problems, and especially attacking the most vulnerable. There's also a lack of information, a lack of proper information about migrants, generating information that majority are benefiting from the system. Undocumented actually can't have any access to welfare or benefits, so misleading the population with information. We've seen the most drastic example of this, I think, is in Greece, and the Commissioner also mentioned his visit there. We co-organized with ECRA and Amnesty International and Greek partners a seminar in December for civil society organizations working with migrants. And I actually found that it was very shocking to hear a number of these advocates talk about the problems that they're facing, which to me are really linked in racism and xenophobia, that seem to me at such a low level as compared to the other levels of discussion that we have with grassroots activists throughout Europe when they deal with migrants. And I think that the incidence of violence, of attacks against migrants from Golden Dawn, the inability to go to report them to the police, there's a fine that they have to pay to then report any claim to the police. Many times the police are also involved, actually fuels this process. So we've seen this kind of the far-right extremism in Greece, but I think what's also more worrying, and that's what I'd like to focus on a little bit, is when this actually becomes more mainstream. When we see this discourse coming into mainstream policies, discriminatory language becomes acceptable, discriminatory policies, and passing these laws and policies becomes a reality. So what is this, how does this actually impact on undocumented migrants? I think the excellent issue paper that the Commission of Human Rights published with CEPS a couple of years ago talked about some trends in Europe concerning criminalization of people who engage with foreigners. And the report said that there's a message that's sent out that engaging with foreigners can be risky and it might result in criminal charges. And who can be engaging with foreigners? Transport companies, employers, people who go about their daily life, landlords, doctors, friends. Contact with foreigners increasingly becomes associated with contact with criminals. And we've seen actually some developments in legislation that depict what this issue report had already referred to a couple of years ago. In 2009 in Italy, there was a security package that was adopted that criminalized irregular stay and entry in Italy. More recently in the Netherlands, the Dutch government has said that people without documents can receive a fine of up to 3,900 euros if they're found in the Netherlands. The government is still discussing a new criminalization package. The deputy minister has said that unlike some other EU member states, the Netherlands won't make it a crime to help undocumented migrants, but this is still an ongoing discussion. I think it's important to notice the difference between the national level and the local and regional level. The cities of Amsterdam, The Hague, Rotterdam, and Utrecht have all formally declared their opposition to criminalizing irregularity. Why? Because it's in their interest for having social cohesion and having their populations not criminalized. So I think that this is also an emerging actor that we have to also try to work more with our local and regional authorities. And the Committee of the Regions is also one of the main targets. Other country-level developments in Spain, the government would like to revise Article 318 bis of the Penal Code, which guarantees fundamental rights to immigrants. The revision would be to inflict prison sentences on people who provide housing to immigrants. So if this revision is passed, it would mean that those who provide shelter for profit, so landlords or slumlords who exploit them, as well as those who provide shelter for solidarity, would be treated in the same way with prison sentences. There's a campaign of many NGOs and some European ones called Salvemos la Hospitalidad, so let's save hospitality, that's targeting local and regional actors once again. So the aim is to get institutional motions in municipalities, provincial councils, and regional governments that demonstrate that this article should be changed. Some municipalities like Malaga have already voted unanimously not to have such an article. In France, recently, the French Parliament abolished a legal provision on the 19th of December that would sanction people who provide support to undocumented migrants, so the délit de solidarité, as has been referred to for many years. The NGO Gisti said in a statement that it's a good step in the right direction, but it doesn't mean that the government has canceled the solidarity offense completely. So it's, I think, good news, but we have to analyze it a bit further. We've also seen cases against human rights defenders, and I know the Commission of Human Rights has also looked at that. One case was against the NGO Kiza in Cyprus, who last June was cleared of more than a year of criminal proceedings when a judge found the accusations against this individual, the director of this organization, to be not credible. The director, Doris Policarpou, had been accused of rioting following racist attacks on participants of the 2010 Rainbow Festival, which this organization had been organizing for more than 10 years. So we see all of these examples, the recent legislative developments, criminalizing support, criminalizing solidarity to undocumented migrants. We also see that there is restricted access to social services and also restricted access to justice as a way of trying to prevent undocumented migrants from coming to Europe. Why? Because they won't be able to access these services, and try to facilitate the return to make it unbearable for them while they're here. So the Fundamental Rights Agency did an excellent landmark report in November 2011, mapping the 27 and access to human rights or social services in the 27. So we see from this report, which is the most comprehensive to date, that there are numerous situations. The example of healthcare. In some countries, healthcare is almost on the same level of access as nationals, so subsidized healthcare, if nationals have access. In other countries, undocumented have to pay, so it's privately paid healthcare. And that's almost unbearable for someone to be able to take that on themselves. So what do we see, basically? What is the impact on the ground? What are the real-life stories? Our organization has members that work directly with undocumented, and so they've been telling us over the year a number of stories. In London, a heavily pregnant woman was told there were severe complications with her unborn twins, but she couldn't receive a C-section until her life is in immediate risk, because third country illegally residing nationals are only entitled to immediately necessary care, as one example. We have cases of, in Ireland, a young woman had to go and undergo a life-threatening procedure by an untrained practitioner because she wanted to have an abortion. She was undocumented. Ireland doesn't allow it, and she couldn't go to the United Kingdom to have that. We have horrendous stories of workplace accidents towards undocumented workers, employers leaving them for dead on the road in many member states. And also the increasing situation of women who experience gender-based violence, who try to go to shelters, who try to go to the police and are turned away because they are undocumented, cannot file a case at the police against their aggressor, and cannot get help in a shelter because many of the shelters have state funds. So what is, and I'll conclude with this, what is a way forward? Also in response to the Commissioner's presentation, how can we try to counter a lot of these developments concerning criminalization of undocumented? One of the first ways, I think, is to reform law and policy to ensure equal access to rights for undocumented, so civil, economic, and social rights and basic services. We have to reform legislation, policies, and practices that will enable undocumented migrants to have access to health care, to education, to fair working conditions, to protection from violence. And I think there are a number of developments that have been happening in different member states in recent years that are encouraging and that should be analyzed more and replicated. Sweden will this year enact new legislation on access to health care for undocumented after a 7-year campaign of all of the major civil society groups in the country. Italy will now have a pediatrician for every child, meaning every undocumented child will be able to access their own pediatrician, also after a campaign. The Netherlands and Spain have had legal rulings allowing undocumented adolescents to have access to internships while they're finishing their secondary education. There are guidelines that the Fundamental Rights Agency has produced, and I think Lotte will describe this a little in her presentation, on detection practices, so how member states can actually allow their immigration officials to be able to do their duties in controlling migration and at the same time enable people to uphold their human rights. The whole concept of having a firewall between social services and immigration authorities. And I think as well, we do have a number of directives now that, although they're from a migration control management perspective, such as the employer sanctions and the return directive, they do have some articles in there that do offer, in theory, protections. Both of these directives now should have been implemented. The question is, what are these articles, what are they being done in practice? And that's something that we'll be analyzing with our network. The other one that has another 3 years to be transposed is the Victim Support Directive. There's an article in the beginning saying that's eligible for all victims of crime. Criminalization of support should be eliminated for undocumented. I think as well the question of terminology. I can't insist enough and underline what the Commissioner has already said, to use terms irregular, undocumented, and not illegal. Just in January, the United Nations Alliance of Civilizations held a high-level seminar on migration coverage in Paris with over 35 editors-in-chief and migration experts from 27 countries, with recommendations, 17 of them, on how the media should cover migration, and not one looked at the issue of terminology. So I think that there's a lot of work that needs to be done, but the work also starts with us as individuals. 3 more short points. Empowerment of undocumented, that they have rights and that they can exercise them, and that's linked to integration. When one does not feel like they are criminalized and they can be empowered to do that, they will also be leaders in that sense. Legal channels through legal strategies, and finally more regular channels for migration, also building on what the Commissioner has said. Family reunification, independent statuses for women, work permits as well, but not at any cost. I think that there's an emerging discussion now, a trialogue on the Seasonal Workers Directive, very welcoming that the EU is looking for more regular channels. The first one's for low-wage workers, but not at any cost, because we have examples from throughout the globe of all the abuses of seasonal workers programs. Thank you.
Thank you, Michele. Thank you very much. Let's now move to the representative from the European Union Fundamental Rights Agency, the FRA, and Charlotte Nygard. It's really a pleasure also to have them here. The FRA has been very active in promoting knowledge and giving policy suggestions on the rights of fundamental rights of irregular migrants and Roma. Here at CEPS, we are, of course, honored to belong to the FRANet network and coordinate for the FRA the expert team network of scholars looking at various issues of asylum, migration, and borders from a fundamental rights perspective. And it was actually in that context also, in this project of fundamental rights of migrants in an irregular situation in the EU, where CEPS provided research and inputs to the project that Charlotte is hopefully going to refer. Please, you have the floor.
Thank you. First, a technical issue. Can you, Sergio, please pass the keyboard, because I have a PowerPoint. Thank you very much. I will, for the warm welcome and the very warm introduction, I will respond in an EU context to the Commissioner's word on world on criminalization. And based on the research on fundamental rights of irregular migrants, we will look at the criminalization in the EU and how fundamental rights have been affected, and within the imperfect fundamental rights perspective of the EU community law in the field of migration, which the Commissioner also pointed out, I will point to certain opening of how states can find way of fundamental rights compliant implementation in any case of these instruments which were drawn up in the atmosphere in the beginning of 2000, where the aim was to combat illegal migration. So again, cannot more agree with previous speakers that the terminology is of the first issue to address when talking about this issue. So this picture is actually based on information from 2011. And in 18 member states, irregular stay is a crime, or was a crime in 2011. In all cases, followed by imprisonment or in fine, or in some cases, such as Latvia or the Netherlands, as you can see from the map. In some member states, those are the ones which are darkest here, there is irregular stay or entry is not considered a crime. We have now, in these days, developments in the Netherlands, where from a situation where irregular migrant which has been considered unwanted has until now been criminalized. In the future, this will extend to all irregular migrants, but not to the children. This is the proposal only. So if we look at the criminalization, what does it entail? What is the flow? What is the consequence? What does it lead to? If something is criminalized, the police is involved, policing is involved. And you need to have direct policing, indirect policing. This is normal flow. So when it comes to regular migration, you have then apprehension, of course. This is direct policing. Or you have the indirect policing, which also Michele referred to, which has to do with the reporting and data exchanges. And what the research which Friday in 2011 clearly showed is that the fear of detection, regardless of a formal entitlement to health or education, will sincerely affect access to fundamental rights, including basic social rights such as education, health, and also housing. Another effect of criminalization, which is beyond the undocumented, which has to do with any national minority, Roma migration population, is that the risk of discriminatory ethnic profiling goes up. And FRA has undertaken a survey on experiences of police stops. And in 10 member states, we did a comparison between experiences among minority and majority respondents with regard to police stops. And I'll give you two examples. In Hungary, 83% of the Roma respondents has reported they have been stopped on the street, whereas only 10% of the majority population said that this had happened to them. In Spain, 81% of North Africans had been stopped in public transport or on the street, in comparison with only 30% of the majority respondents. But let's get back to the situation of the irregular migrants, the undocumented migrants, and look more carefully at two directives, the Return Directive and the Facilitation Directive, and see in more detail in their existing imperfect situation, are there ways towards a more fundamental rights compliant way of implementing these? Are there possibilities? Let's first look at the return directive. As I said, the fear of detection was the thing which was a practical barrier for regular migrants to refrain from approaching schools and hospitals. This could be a real fear or only the perceived fear. The rumor is enough to trigger off this kind of belief that you will be apprehended. Are there ways within the return directive to address this issue? Actually, there are, because there is nowhere in the return directive it is said that you need to apprehend irregular migrants everywhere and by all means. Article 6.1 of the directive says that the state has a duty to issue a return decision to illegally staying third country nationals. Nothing more than this. And for years, actually, PICOM and also other NGOs have been advocating for setting up firewalls to stop data exchanges between service providers and law enforcement authorities. And based on the wording of the return directive, the input of law enforcement officials in member states, PICOM and the European Commission, all the four of us, so to say, worked together and came up with a document, a practical document providing guidance, kind of do's and don'ts on what to do in an apprehension situation. And it's a very simple document, basically saying you should not apprehend irregular migrants at or near schools, hospitals, civil registries, and irregular migrants should be able to report crime to the police. And data exchanges between these and immigration law enforcement authorities should not be required. Now, these were analyzed, and from a starting point, it is also clear in this document that there are other interests than fundamental rights which are represented by adopting this approach. Public health is one concern, crime prevention another, promotion of voluntary return a third one. That's one way of trying to promote fundamental rights compliant implementation of existing EU law. Let's move to another right, the right to housing. The debate about solidarity crimes, which was mentioned earlier. The punishment for renting shelter to irregular migrants is an effect of criminalization. In those countries here which are dark red, and this is again based on information from 2011, there is no punishment for renting accommodation to irregular migrants. In those which are pink here, this is not excluded that renting of accommodation to irregular migrants can be punished. It can happen in theory, but not necessarily in let's just say there's a legal possibility, but there are no cases. Or we had kind of contradiction information that NGO states that this could indeed happen in certain situations. In those countries where you are striped, here we have we had an express prohibition against renting accommodation. And the grey one, renting of accommodation to irregular migrants is treated as facilitation of irregular stay, and it is thus a punishable offence. So that was the bleak situation, if I may say, when it comes to criminalization of providing housing, which might, in the worst case, even affect the dignity of the irregular migrant. We have the facilitation directive, which, if interpreted in one way, allows exactly for this behavior, but not necessarily. The EU Facilitation Directive imposes a duty on EU member states to punish anyone who assists a person who is not a national of the member state to enter or reside in breach of the laws of that state. This is the main purpose. But that was Article 1. Article 2 say the provision of humanitarian assistance should be, member states have the possibility to exclude the provision of humanitarian assistance from punishment. Based on two projects, the housing situation came strongly up in the project on the fundamental rights of irregular migrants. In another project, which FRA is producing its results right now and will launch next month on the fundamental rights at the southern sea borders of the EU. In both projects, the link to increased use of the humanitarian assistance clause in the facilitation directive is recommended. And the renting accommodation should thus be considered as a humanitarian assistance, and the rescue of regular migrants who come in unseaworthy boats or overcrowded boats across the Mediterranean should also be considered as a humanitarian assistance and thus be excluded from risking punishment under the Facilitation Directive. So what is needed? As I said, there is an imperfect situation from the EU legislation, from the fundamental rights perspective, but there are practical ways to work around those issues so that for the states to act in a fundamental rights compliant way when implementing the migration policy. But there is also a need for more robust, let's say, standards or a more robust human rights language around the whole migration control approach to the migration policy in Europe. Thank you.
Thank you for your comprehensive presentation. Let's move immediately to our next discussant, Professor Mike Hough. He's co-director of the Institute for Criminal Policy Research at the University of London and one of the scientific minds behind the FIDUCIA project. We welcome you, and we'll also very much like to know how this debate is framed in our project. If you could let us know the framework of FIDUCIA and the links with questions of migration and minorities, please.
Good. Thank you very much. I always feel rather compelled to apologise for being British in events like this, as our politics get increasingly more insular, and being foreign is bad even before they try and come into our place, and we're going to stop them. But I can't do anything about that, I'm sorry. About the compulsion or the political facts. I'll say a little bit about FIDUCIA, this project, EU FP7 project, and trace its implications for the criminalisation of migrants. In a word, I think the conceptual framework we're using in FIDUCIA could be very useful for advancing the ideas of human rights in the treatment of irregular migrants. So that is what I'll do. The ideas behind FIDUCIA are that policy needs to spend more time thinking about normative compliance and about normative levers for affecting behaviour, and less about the straightforward instrumental strategies of deterrence and punishment that politicians tend to grasp first. It's important to recognise that people are moral agents and that the quality of the justice to which they're exposed affects decisions to engage in crime, to engage in illegal behaviour, to conform with regulations, and so on. FIDUCIA is grounded very much in procedural justice theory, which is emerging from the States, having been exported there from Europe, of course, with people like Weber and Durkheim. The basic idea of procedural justice I would encapsulate as follows. If legal officials treat people fairly and respectfully, that engenders public trust. Public trust purchases or builds the legitimacy of institutions of justice. Legitimacy is an absolutely core concept, I think, in doing social order in a civilized way, because the legitimacy of the police, the courts, and so on, generates, on the one hand, compliance with the law, and on the other hand, cooperation. One wants people to comply with the law and cooperate with the law, and they won't do so if they regard the law as lacking in legitimacy. And there's good evidence that normative compliance, where people comply with the law because they think it's right, is better and less costly than instrumental compliance. The sort of questions we're trying to answer in this 3-year project, we're 1 year in, but 3-year project, is can regulation be better done through normative, what we're calling trust-based strategies, than through deterrence and imprisonment and so on? How closely should criminal justice be aligned with moral values? And there are very interesting questions about whether the normative levers that exist within a country in criminal justice flow across boundaries. Whether people take an internalized sense of what they ought to do in obeying the law from one country to another as they travel, and how can one maximize that effect. Let me say a little bit about why I think procedural justice theory is useful in the consideration of the criminalization of irregular migrants. I think it's really useful to use concepts of legitimacy in thinking about this issue. Are the strategies of control regarded as legitimate by the people who are migrants themselves, by their families, by their friends, by their employers? The legitimacy deficits that could be created by mistreatment of irregular migrants could sort of flow out over quite a large number of people and damage the legitimacy of justice. There are costs in criminalization on the first place, distrust in the rule of law. If you have a system of treating migrants that is blatantly unfair, that will damage the rule of law. You will lose compliance, you will lose cooperation with the law. Worse, non-compliance could turn into defiance. And when you talk about second and third generations of migrants, you can have very vicious spirals of over-policing that echo through generations. That's certainly the UK experience in the policing of black communities, where you have 3 or 4 generations of unsolved tensions between police and black minority groups. It's important to realise the damage that is created both for host and home countries. If somebody is moving to a country and arrives there thinking that the justice system has really abused them, that's bad for that person, bad for that country. If they go back to their home country, they probably go back a more alienated person. I mean, the idea that justice stretches, I can't say it, beyond national boundaries seems a rather important one. And we ought to think about how to build a pan-European sense of legitimacy in justice. What's FIDUCIA doing? Well, it's basically working with 4 case studies of 4 types of emerging European crime. Trafficking of people, trafficking of drugs, cybercrime. Those are 3 quite clearly emerging criminal problems which could be policed, regulated, controlled in ways other than conventional instrumental strategies of deterrence. And the 4th is the policing of irregular migrants and minority groups. The work has been led by CEPS, and it's going to involve a review of law and practice across Europe. It's going to look at the criminalisation of culturally valued behaviours. It's going to look at the policing of Roma communities, and there will be work on public perceptions. Obviously, how the broader public see minorities, see migrants, is critically important. And that's all I have to say. There's a website on FIDUCIA. CEPS are here if you want to ask them more things about this particular dimension of the project, and I hope that we'll produce something useful over the course of the next 2 years. Thank you.
Thank you. Thank you very much, Mike. Indeed, fiduciaproject.eu. This is the website where the main results of the project and events, related activities are regularly posted, and we invite you to visit it, of course. Next speaker, next discussant, Professor Elspeth. She's a Senior Associate Research Fellow here at CEPS, but she's also Jamone Professor at Personen at Radboud, University of Nijmegen, and at Queen Mary London. Her work on migration is being wide and extensive, not least, indeed, the issue paper, which has been provided in the entry of the room. The paper she did on the criminalisation of migration in Europe, human rights implications for the Office of the Commissioner, that of course we highly recommend you to see, as it provides very relevant results and policy recommendations. So Elspeth, you have the floor.
Thank you very much, Sergio. That's a very kind introduction. And I have found the presentations this afternoon extraordinarily interesting. I would like to thank very much the Commissioner for his continuing engagement with this issue, which is one of the most troubling human rights issues which is facing us in Europe, and which, as yet, we seem to be struggling with finding proper approaches. I think the approaches that we've heard from our other speakers have been particularly helpful and useful in thinking about where do we go, how do we take this forward, how do we get out of this terrible spiral that we're in around the treatment of people as soon as we call them undocumented, illegal, and irregular. I'm going to very rapidly just run through some of the key issues. And I think the first thing we have to think about is, what are the crimes that only foreigners can commit? And these are all crimes about state sovereignty and the border, and the relationship of an individual with state sovereignty and the border, and the determination by the state in the exercise of its sovereignty of what someone is. So citizens cannot commit these crimes. They can only be committed by someone who is not a citizen. And of course, the first is clandestine entry onto the territory. That usually means arriving without encountering any kind of immigration officer. Illegal entry onto the territory, which is usually meant to be arriving, going through some kind of immigration control, but managing to provide misinformation in order to get access, entry on false documents, then once within the territory, working without authorization, staying on the territory without permission, that's usually called overstaying, failing to leave the territory when issued with an expulsion order, and failing to assist with one's own expulsion. Those who followed the US election campaign will have noted that Mr. Romney, who did not win, used the immigration idea of getting the illegals to deport themselves, and that's a crime in many member states, failing to do that. And then there are a series of crimes in Europe which can only be committed with foreigners. So these are crimes which are no longer ones which only foreigners can commit, but the category that Anne Charlotte was talking about, how do you send out the message that knowing foreigners is dangerous because you may commit a criminal offence? And these are, of course, assisting illegal entry, we saw the map, assisting clandestine entry, harbouring a foreigner without permission, and that, under that heading, comes that category of the housing. Be careful who you rent your apartment to. You may be committing a criminal offence. Assisting a foreigner to remain unlawfully on the territory, employing a foreigner without permission to work, trafficking a foreigner for illegal work or exploitation. And in that one comes the question of what is the difference between an acceptable activity in running, for instance, a taxi company which crosses borders, and what is considered trafficking, and assisting a foreigner to evade expulsion, so assisting someone not to be expelled. It's quite it takes some thinking about to consider what kinds of, how widely these kinds of criminal activities can go, and how many people are potentially touched by them. And in that context, I want to move then to a brief look at the statistics we have on what kind of problem we're looking at. And these are all the statistics of Frontex, the EU External Border Agency, in its 2012 annual report on 2011. And here we see that our annual EU admission of third country nationals is 710 million people a year. Remember, the population of the European Union is only 500 million, so we admit more third country nationals than live in the EU at any given time, any given year. The refusal of entry at the external border, we see it was 1,118 in 87. We have a very accurate figure from Frontex. The European Commissioner has given us a different figure, which is perhaps less, makes fewer claims to accuracy, 343,000. And I will leave it to them to explain the difference in the figure. What I want to say there is, if we're talking about refusal of entry, who are the people we don't want to let in because we think they are going to commit these crimes? Out of that 710 million, 118,000 is, a statistician would call that statistically insignificant. What are the resources we are throwing at this question? I'm going to just jump over the figure for clandestine entry because it's so low that it's quite difficult to deal with it. Irregular border crossing, Frontex considers that there were 140,980. And person categorized as irregularly staying in the EU 350,944 according to Frontex, and 468,500 according to the Commission. Frontex thinks it has a better grip on the figures than the Commission. In total, what are we looking at? Our total number of people, according to the experts, the EU experts. Of course, the Commission gets its information from the Interior Ministries. Frontex gets its information directly from the border guards, which is part of the reason for the difference. But the overall number of people that we're looking at in terms of the amount of criminalization that we are undertaking requires us to think about what Mike was speaking about, the legitimacy of this project. If we then look to the next question, what about profiling? Who is it that we are interested in? According to Frontex, refusal of entry at the external border, you have your figures there for 2011. And of course, Albanians are high on that list, primarily because the lifting of the mandatory visa requirement for Albanians only applies to Albanians with biometric passports. But not all Albanians understood they had to change their passports, so they kept on turning up at borders with old passports and got refused. Undoubtedly, that's changing. The Ukrainians, Russians, and Belarusians, of course, all need visas to come to the EU, where the Serbians are now free of visa requirements. Who comes irregularly? According to Frontex, our top nationalities are Tunisians, Afghans, Pakistanis, Nigerians, and Algerians. And as soon as you look at that list and you think of the events over the last 2 years, you can understand why perhaps these people are turning up at our borders. One looks at questions of human rights abuses in countries, one looks at massive upheaval and transition, and these countries are not far from the top of those lists. These are also countries whose nationals must have visas if they want to come to the EU at all, and where, if you look at the Commission's figures on the refusal of visa applications, they come just about at the top. The two sets of lists also raise very interesting questions about the geopolitics of the refusal of people at the external border. These are the people who we are thinking are the ones who are likely to be irregular. How does this become a human rights issue? And I think it's very important to bear in mind what Michele mentioned about the decriminalisation of the facilitating crime in France, to remember that in November 2011, the case of Mr. Mala versus France came before the European Court of Human Rights. Mr. Mala was a Moroccan national. You've got the facts there. He lived lawfully for more than 30 years in Corsica with his wife and children. His 22-year-old daughter married a Moroccan man in Morocco. The son-in-law obtained a visit visa, came with the family to stay with the family in Corsica. The daughter fell pregnant during the visit, and the son-in-law overstayed and sought family reunification from within France. So yes, he was illegally present, according to French law, but he had made an application for family reunification and sought an exercise of discretion for that to be considered within the country. But he was denounced to the police, and the police arrived at 6 a.m. at the family house. They arrested the young woman's father, the husband, who was Moroccan. The two Moroccans placed them in pre-trial detention and charged the applicant, which is the father, with the crime of assisting illegal residence of a foreigner. The son-in-law was expelled to Morocco and eventually did get a visa to join his wife in France. The Moroccan, Mr. Mala, was convicted of the offence, and in his claim to the European Court of Human Rights that there had been a breach of his respect for family life in this conviction, the court found that there was no violation, but only on the basis that by that time the French authorities had undertaken that there would be no punishment for the offence. Undoubtedly, the publicity around this aspect of criminalisation assisted in the campaigns in France to have that offence withdrawn. There is another example from September 2011 where there is a violation of Article 8, the offence of being a foreigner. And here you have a young Cameroonian national admitted to Russia as a child to work for a football club. Because of injury, he had to give it up. He remained as a student, then he fell into irregularity. He had 2 children with a Russian national. Undoubtedly, they couldn't marry because of his undocumented status. He was arrested in an identity check. He was given a transit visa and told to leave the country. He couldn't, as his partner had just given birth. As public offices were closed, he could not seek a new residence permit, and on expiry of the transit visa, he was charged with overstaying, went through a series of very rapid trials, and ended up with his conviction and detention for the purpose of expulsion. And in that case, we can say that perhaps the European Court of Human Rights took slightly more seriously Article 8 and the right to family life, finding a violation. These cases are only the tip of the iceberg in respect of the problem of the criminalization of irregular migration and of people who know foreigners. They represent part of the problem, but I think they indicate just how important this problem is for us, what a challenge it is to our capacity to present ourselves in Europe as human rights compliant, as concerned about the well-being and the fundamental rights of people who we classify ourselves as somehow being irregular, not just irregular, but by their very existence, illegal in Europe. Thank you very much.
Thank you. Thank you to all of you. We have about 15 minutes with the kind acceptance of the Commissioner to run 5 minutes late. 4 questions. I will highly recommend those of you who like to pose questions to really make it as short as possible, as concise as possible. Limit your interventions to time in order to have as many as possible. And introduce yourself as well. So we have our first minute.
Thank you. Frank Powell, European Commission. I'm the head of the task force. Start again. Frank Powell, European Commission. I'm the head of the task force Irregular Migration in DG Home. Now, Commissioner, you said that you plead in favor of making the irregular crossing of a border a administrative misdemeanor type of action. Now, we've seen that most of our member states do not follow that advice. They make it a criminal offense. The obvious reason being that they think this is the only thing that works as a deterrent. We obviously can't let everybody in. That's a simple fact of life. So if you want to make people comply with the law, you have to use a deterrent. So if you move it to administrative misdemeanors, the claim is the deterrent is gone. Is that so? Or in other words, what do you suggest? How would you make the deterrent work if it's not via making a violation of the law a criminal offense? Thank you.
Perhaps I will gather a couple of 2 more questions before opening the time for answer. Yes, we have some.
Thank you. Constanze Hermann, Open Society Foundations. So the first, I was very happy to hear Commissioner Muižnieks criticizing the Dublin system. I think that the Parliamentary Assembly of the Council of Europe, especially regarding Greece, took a very definite stance on that very shortly. And I know that other human rights monitoring bodies were active in Europe at the moment, and I refer in particular to the activity of François Crépeau, the UN special rapporteur on the human rights of the migrants, are taking a firm position on that too. Now, the Dublin, the entire EU asylum package is just being renegotiated. I think that this criticism from human rights monitoring bodies is very important. What, in your view, the likelihood that this could have an effect in Brussels and in the within decision makers in Brussels? And I ask this to Commissioner Muižnieks, but also to Sergio and Elspeth, who are very much into Brussels politics. And the second part of the question is, in a way, a follow-up to the question which was raised before mine. I found it completely fascinating, the presentation by Professor Hough on the effects of criminalization, and I think that possibly one response on the deterrent effect and the possibility of deterrence when criminalization is transformed in or transformed back in administrative misdemeanor is this gaining from the point of view of trust in law enforcement. I think there has been some experience on that, not in relation to border control, but in relation to racial profiling by police, in particular in the UK with experimental policies working with police and explaining them by not profiling racially minority communities, then there is increased trust in law enforcement and that potential good effect on majority-minority relation and minority-police relations. Do you have any good example of that for border control that you can cite? Thank you.
Thank you. One more question, please.
Thank you. I am Daphne Bouteguet-Paquet, representing Caritas Europa. I would have two brief questions. One first for the Commissioner. I would be interested to hear from you, sir, whether you have developed some sort of institutional dialogue with Frontex, because we've been talking about criminalization but I think the operational side of things is very important to this subject today. And my second brief question would be to Professor Hough and Sergio Carrera. In the project FIDUCIA, precisely, are you covering that side of things? And I don't want to overburden your very busy agenda, but if not, I think that would be a very interesting angle to include to that project or any further project you'd like to develop. Thank you.
Thank you very much. Commissioner.
Yes, thank you for these questions. I think the question I would have is, if it's considered a deterrent, does it work? I think there are many member states who think the longer we detain people in the worst conditions, the news will get out and people will not come. I think this flies in the face of the facts, the migration facts we see on the ground, that it doesn't matter if you detain people or not, people will continue to come. It doesn't matter what conditions they're in, people will continue to come because they're desperate. They're either desperately poor or they're desperate because they're being persecuted. So I would question the assumption that it's a deterrent that has any chance of ever working. That's the first thing that I would question, and I would challenge anybody to prove that it does work as a deterrent. From a human rights perspective, detention should only be used as a last resort. And it should be used only with a view to removal. Why detain somebody for 18 months? Why do this? It's a completely inhumane, it's a costly, inhumane policy. If after 2-3 weeks you realize that you are not going to have, the person doesn't have documents, the potential country of origin is not going to cooperate, why detain this person if after all of this detention you're going to let them loose anyway? I think it's a pointless policy, and there are many alternatives which I mentioned to it. So I think that this is a fundamental thing. Prove to me that it works as a deterrent. And second of all, does detention should only be used with a view to a certain purpose, which is removal. And if you cannot do this, and the Greeks, they claimed, oh, it's working. They're deporting about 25% of the people that they detain. What about the 75%? What about this? And this is high. This is a high percentage. Many other countries, I think, detain many thousands of people and maybe are able to deport 10% of them. So again, if you look at the overall figures, it's kind of an absurd, ineffective policy, and I would challenge anybody to prove that it works as a deterrent. And I have not seen any evidence that it does work as a deterrent. Regarding the Dublin returns and the Dublin system, impact on decision makers in Brussels, I think we have a regular and ongoing dialogue between the Council of Europe and the EU We cooperate, but I consider it our task as well to criticize the Commission if we think they're doing a bad job on human rights. The Commission and the various parts of the European Union are a strange beast with many heads. And we have to talk with all of the different heads, whether it be the Fundamental Rights Agency, the Commission, the External Action Service, the European Court of Justice, and the European Parliament, and so on and so forth. And we're still, to be honest, I'm a bit bewildered sometimes about who I must talk with on some of these issues. Can we have an impact? I don't know. I think often I see that our impact can be assessed many years down the line. I've seen this with my predecessor's work. I go to a country and I say, "Oh, this is a very good reform that is being carried out now." And they said, "Yes, this is because your predecessor began raising it 6 years ago." So I think there's a real necessity to take the long view on these things. But what really strikes me is a lack of a political debate about Dublin returns. Is that this policy was agreed when people had no idea what they were signing up to, that it clearly has not worked, and it has been undermined by legal challenges, but there is I sense no real will to revisit it and reopen the discussion. But as I say, I think the clock is ticking. Greece is on the verge of fixing its migration system, and then what happens? What happens? Are people really going to start returning people to Greece? That to me would be a shocking news and shocking short-sightedness. Regarding Frontex, to be honest, I've had no contacts with Frontex until now. Frontex, I know FRA has a special fundamental rights training and officers with Frontex. Frontex is a pretty secretive organization that cooperates with member state militaries. They're not very open to cooperation with, as far as I know, with external human rights bodies. I hope you're wrong. I hope I'm wrong, and I would be very interested to engage with them, especially in the South, but not only in the South. But until now, to be honest, we've had no contact with Frontex, at least not since I took up office.
Thank you very much. Elspeth, would you?
Yes. I think that I would just come back to Mr. Paul with one comment, which is when we look at the statistics of what happens in terms of border controls on persons at the external borders of the European Union, with 710 million entries per year and under 120,000 refusals, I think we have to bear in mind that what's happening is something that is the equivalent of checking bus tickets. This is not a policing activity which is going on. The numbers are so small that if you think that this is about deterrence, it seems to me you would need to see quite different practices on the ground. Rather than those ones, particularly when one then begins to unpick them and look at the grounds for refusal, why people are being refused at the external border. And they are extremely administrative. Failure to have a visa from a national of a country which requires a visa is by far the largest ground of refusal. Anything about crime is extremely low. There are 2,000 refusals were on the basis of anything to do with an entry on this Schengen information system or other kinds. So I think we need to be quite careful about what we're doing. I wanted to come back to the question on the Dublin system, and I think that there were quite a number of us who expressed dismay at the Dublin system from the very beginning. It's an extraordinarily odd way to go about thinking of protection for persons in need of international protection and moving them around. And if you look at the statistics from the Eurodac annual reports on the numbers of persons who get moved back and forth across Europe under the Dublin system, you wonder at the sanity of anybody who keeps running this system, where you have in quite a number of member states similar numbers of people being moved to another member state and being brought back to that state. And you think, well, that's an amazingly stupid waste of money. why don't, you know, we must have some better way of doing this than that one. And then you have a number of states which take a huge hit, often states which are least well prepared or able to deal with it. And I think that the practice indicates that this is an extremely expensive system which causes real problems of legitimacy. It's also caused, and I think we signaled this at least 7 or 8 years ago, it is the source of the most problematic questions of the constitutionality of the European Union in terms of fundamental rights between the Court of Justice in Luxembourg and the Court of Human Rights in Strasbourg. Utterly unnecessary, completely and utterly unnecessary, that we should be throwing into disarray the constitutional organization of Europe over an issue which, I mean, this is really the case of tails wagging dogs.
Just briefly, the question about alternatives to deterrence again in border control. FIDUCIA, you'll forgive me if I get it wrong, but at the moment it's still early days, and we'll be reporting in 2 years' time, and we may well be saying there are better alternatives to straightforward deterrence. I think it's as likely that we'll also be saying you can do deterrent criminal strategies in a way that has less collateral damage to system legitimacy than is done at the moment. And that might be the really important thing that we could say.
If I may add to that, I think that questions of the approach that was taken in Elspeth's intervention is central for an independent research project, where we look at what are we talking about, what do the numbers tell us, and what is the knowledge, the evidence that policymakers, not only European Union levels, but also national levels, are using to justify this kind of repressive approaches, public policy approaches. So, you know, what does it justify? And this brings us back to the question of legitimacy, which I think is indeed central when looking at, you know, the very excellent overview of number of entries and, you know, why is this such an issue? Why are we framing, why is the European Union also contributing to the framing of this phenomenon as an insecurity, as a threat for European Union? This is something which we will address in our research, the role of agencies, of course. EU Home Affairs agencies. We've published the first paper in FIDUCIA project by CEPS, my colleague Joanna Parkin, a very thorough analysis of the role of EU agencies such as Frontex, Europol, in precisely the same thing, in framing human mobility as a crime, in framing certain groups and profile certain groups as potentially, you know, more criminal than others. And the extent to which we can increase trust in this, you know, in the knowledge which is actually backing up this phenomenon as potential crimes. So this is clearly at the heart of, has been at the heart and will continue to be at the heart of the interest in FIDUCIA. Impact, I mean, this is a constant struggle. I mean, you know, we as a think tank have been working very hard in providing objective, impartial, independent knowledge on these questions for, you know, many years already. What is impact? I think we really need to critically assess what is impact and stop measuring the success of certain discourses, projects, knowledge, research, only if you see visible, you know, reference or impact in certain, for instance, European Commission activities. I think that's something that we are seeing, however, in Brussels, my own experience, and that of the Justice and Home Affairs section at CEPS, is that independent critical research is more and more contested, is less and less welcomed in certain venues. And I really hope this will change, because when looking at the functions of knowledge and you know, public policy research in precisely, you know, giving the background for debates to be legitimate and trustworthy, you know, the work of institutionalized CEPS, you know, will continue be as active as usual. But however, I will indeed look critically at this question of the impact. And last but not least, who are the actors? Yes, this is key. with who to speak about these questions. This is also, I think, a challenge for the European Union institutions themselves. They are still struggling who speaks about what, not least the European External Action Service and DG Home Affairs, which are finally finding each other more when going abroad to talk about these questions in relations with third countries, but that constitutes a challenge also for the European Union itself, and will continue doing so in the future. I think we are up of time. I'm afraid I need to close the session and the seminar by thanking again the Commissioner, the discussants, and of course all of you for having participated in this event, and we look forward to future cooperation and following up your activities. Thank you.